Welcome back to Counting to Five, a podcast about the United States Supreme Court. I'm Mike, your host. This is our weekly YouTube live stream being broadcast live Thursday, February 15th, 2018 at 9 p.m. Eastern Time. This live stream will also be posted as an episode of the Counting to Five audio podcast. If you're watching live, please feel free to ask questions in the YouTube live chat at any time, and I'll try to monitor the live chat and periodically answer any questions as they arise. And in the weekly live streams, we try to basically keep up to date with the latest Supreme Court news, what's been happening in the court, and what we expect coming up soon. The court returns for its February oral argument session next week. So in a few minutes, I'm going to preview the 4 cases that the court is going to be hearing argument in next week. But first, before I get to that, I want to briefly recap where we are in the term right now. So right now, for the last few weeks, the court has been in recess between its January and February oral argument sittings. And this has been a very quiet week. So if you watched the live streams for the last few weeks, you may remember that there were a number of stay applications. There were some emergency death penalty stay applications. There were some stay applications related to election-related cases, emergency motions asking the court to step in and take action. This week, there's been nothing like that. It's just been a very quiet week, nothing really happening at the court. But the court gets back to business tomorrow. So the oral arguments start up next week, but tomorrow they'll be back meeting in conference. So I'm just going to give a little background on the court's schedule and kind of how they do business. So the court starts its term in October, and every month from October through April, the court sits for oral argument for 2 weeks. They say Monday through Wednesday, 2 weeks each month. Sometimes those sittings are named by the month, the October sitting, the November sitting. Sometimes those dates are not actually all in the month that they're named after because they'll overflow at the beginning or the end of the previous or the next month. But in any case, there's 7 2-week sessions between October and April. Now, typically the court holds 3 conferences each month. They hold a conference on the Friday immediately before the argument session begins, and then on the Friday of each argument week. So since the February arguments start next week, they have a conference tomorrow, and then they'll have a conference again the next 2 weeks. Now, at these conferences, they consider various things. In argument weeks, one of the things they're doing is actually voting on cases that they heard earlier in the week. But one of the main tasks that they're always doing every time they have these conferences is considering the petitions, the cert petitions, the formal requests to the court to take cases. And if you've been following the court, you know that the court receives thousands of these petitions every year, 6,000 or 7,000 in recent years, and they only take somewhere in the ballpark of maybe 70 cases. So maybe 1 in 100 cases gets accepted. So mostly they're just rejecting cases. But they have this conference typically on Fridays. Sometimes if there's a holiday on Friday or something like that, it'll be Thursday instead or something like that. But they have these conferences, and then normally the Monday morning following the conference at 9:30 in the morning, the court issues an orders list, and that orders list consists of various orders that came out of the Friday conference. The main thing is cert petition grants and denials, and again, this is mostly denials. There in a given week, there may be dozens or even hundreds of cases that the court has decided not to take, but there may be also a few grants, some cases that the court has decided it wants to have full briefing and oral argument in. But then the orders list also contains various other miscellaneous orders relating to the briefing in different cases, requests, orders on requests for time extensions. There's also attorney discipline when members of the Supreme Court bar have been disciplined or disbarred from their state bar. The court has to deal with that. But just various miscellaneous orders. Sometimes there's interesting things in there. But these orders are just simple little one-line orders, usually with no explanation at all of why the court is taking a particular action. The court just announces that it is granting or denying certain cases, or it's granting or denying some motion or request from a party with no explanation. Occasionally, along with the orders list, there will also be formal opinions related to orders. And that's when some justice kind of really wants to make a point, wants to say something, make a public statement about why they are voting a certain way, or why they disagree with something the court has done. They'll issue that, but that's an occasional thing throughout that you'll see throughout the term. Now, on oral argument days, arguments start at 10 a.m. But if there are any opinions being issued that day, opinions in argued cases, these are issued at 10 a.m. Immediately before the oral arguments begin. And typically, the opinions are issued on either Monday or Tuesday morning. So next week, Monday is President's Day, and it's a court holiday. So the court's only hearing arguments on 2 days, on Tuesday and Wednesday. So Tuesday morning, we can expect to see an orders list at 9:30 in the morning, and court watchers will be keeping a close eye on that to see if there's any new grants of new cases. And at this point in the term, anything new pretty much will be on next. Basically, anything that's granted from this point out in the term will be next term. These will be things that will be argued in October. Starting in October for the next court term. And then if there's any opinions coming down, those would come down at 10 a.m. prior to the Tuesday oral arguments. Now, there's always, people always wonder when the court is going to be issuing opinions. The court doesn't give any advance indication of when particular opinions are going to be issued. However, typically on Friday afternoon, prior to a week when the court is going to be issuing orders or having oral argument, the court's public information office has a telephone line where they will actually indicate whether they're expecting opinions to be released. This line it's a recorded message, gives no indication of the number of opinions that are going to be released or which cases are going to be released, but there is a little bit of advanced warning that some opinions are going to be coming down. So tomorrow, there'll be anyone who wants to just call that recorded public information line can find out if there's expected to be opinions. Now, we probably will start to see some more opinions pretty soon. This case has had a very slow start in terms of opinions being issued. So far, there's only been 4 opinions in argued cases, which is very low. And there's another 30 cases by my count that have already been argued this term. So there's 30 cases that are still pending where we're waiting on opinions, some of those dating all the way back to October. And we're expecting another 30 cases between February, March, and April. Now, the April calendar for the April arguments hasn't been released yet, but the expectation is between February, March, and April, there's going to be 30 more cases. So that's 60 more cases that the court is going to issue opinions on between now and the end of June. And just to put that in perspective, there's less than 20 weeks left in the term. So, they have to average more than 3 cases a week to get them all out. Now, the opinions are always backloaded in May and June. Their arguments end in April, and then May and June, they're just trying to get all the opinions out. So it's always backloaded, and we can expect a higher number of opinions to come out toward the end of the term in May and June. But still, we should be starting to see some opinions rolling out of the court. It's been a long time since the October arguments, and so we should be seeing one. It would not be surprising if there's at least one opinion coming down next week. But again, we don't know yet. One more thing, just one more thing that court watchers are kind of keeping a close eye on. A highly watched case is there's a case involving the challenge. A legal challenge to President Trump's rescission of President Obama's DACA program. That's the Deferred Action for Childhood Arrivals immigration program. And what had happened with that case is that the Trump administration had issued an order rescinding the Obama administration's DACA policy and beginning a wind down of the program. There were some immediate legal challenges to the Trump administration's action, And back in January, a district court in California issued an order ordering the Department of Homeland Security, who administers the program, ordering them to maintain the DACA program, saying that the rescission was illegal. The government responded to that by filing what's known as a petition for cert before judgment with the Supreme Court. This is an unusual step where a party asks the court to bypass the Court of Appeals and immediately take a case directly from the district court, just to get faster review. And it's rarely sought, and it's very rarely granted. However, a few weeks ago, in response to this, the court ordered expedited briefing on the cert petition. They ordered the parties to brief it on a faster timetable, presumably so that they could consider the petition as soon as possible. And it's due to be considered at tomorrow's conference. It's expected that if the court decides to take this case, and that's a big if, no one knows if they will necessarily take it, but if they do decide to take the case, it's expected that because they ordered this expedited briefing, they're probably going to want to get it on the calendar this term. So maybe that would mean expedited briefing to fit it into the April calendar. There'd be a very, very short timetable for a Supreme Court briefing, but they could do that. Or maybe they would hold a special argument session in May. They've done things like that in the past also. And because of this expedited timetable, if they do decide to take the case, it seems likely that they'll issue an order sometime tomorrow rather than waiting for the normal Monday morning, or in this case Tuesday morning, orders list. So people will be keeping an eye out late afternoon tomorrow to see if the court grants that case and it gives any indication of when it's going to appear on the calendar. So that's just something that's it's being watched, still an unknown. Again, nothing else much has been happening at the court in the past week. So I think it's time to look ahead to next week. And as I mentioned, there are 4 arguments being heard next week on Tuesday and Wednesday. And there's kind of a theme for the week. All 4 cases are related to criminal procedure. They're all very different issues, but they're all related to criminal procedure in some way. I'm going to give kind of a brief preview of each of these 4 cases. However, I released podcast episodes both on YouTube and on the audio podcast feed that are individual episodes dedicated to previewing each of these 4 cases. One of the cases, the first one I'm going to discuss, I released an episode 26 about 2 weeks ago, and then the other 3 came out earlier today. So those are episodes 29, 30, and 31, either on YouTube or on the podcast feed. I'm going to, just for purposes of the live stream, I'm just going to give kind of a very abbreviated summary of each of these cases. But I encourage you, if you're interested in any of them, to check out the episodes devoted to each of those, where I go into more depth and give a kind of a lengthier, more detailed discussion of the arguments and things that are in play. And also, if anyone who's watching live on the live stream has any questions about any of these cases as I go through them, please feel free to throw those questions in the live chat, and I can go into more detail on anything that people want to hear about. But now let's just take a look at these cases. So the first case, this is the first case that's going to be argued on Tuesday morning, is called City of Hays, Kansas v. Vogt. And this is a case about the Fifth Amendment's right against self-incrimination. And this is the familiar the right to remain silent, or it comes from language of the Fifth Amendment that says no one shall be compelled in a criminal case to be witness against himself. And this case, the facts of this case are a little different from a typical Fifth Amendment case. And so here's what's going on. It involves a police officer. And this police officer was the subject of an internal investigation into potential misconduct on the job, and was ordered as part of that internal investigation to give statements about some of his actions, and these are actions related to him acquiring and keeping a knife during the course of his police work. And the briefs in this case are very vague about exactly what the situation was and how he acquired this knife, and what exactly was wrong with what he did. So it's just very vague, and you have to speculate about what was actually going on there. But something happened where he acquired a knife, reported it, and then was subject to an investigation. Now, where the Fifth Amendment comes into this is he was required to participate in this investigation on penalty of losing his job if he didn't participate. Now, there's case law that says for public employees, if they are required to give statements in the course of their job, then the Fifth Amendment prevents those statements from being used against them at a criminal trial at a later date. What happened here was, as a result of this investigation, information was given to the Kansas Bureau of Investigation, which opened a criminal investigation against this officer, and eventually he was charged with crimes related to his acquisition of this knife. And again, the specific crimes are not described in the brief, so it's very, very vague again. But he was charged with crimes. Now, these charges were eventually dropped, and he was never prosecuted for it. However, before that happened, there was a probable cause hearing in the criminal case. And this is just an early hearing that it's part of Kansas's procedures, where the prosecutors have to show that there's probable cause in order to continue their prosecution. And at this probable cause hearing, they introduced the statements that this police officer had made in these internal police investigations. And so what happened is this police officer ended up losing his job. The charges were dropped. However, he subsequently sued various people, but including his police department and some of the police officers. But he sued the police department, arguing that they had violated his Fifth Amendment rights by causing these statements made in internal investigation to be used against him in the probable cause hearing. And this is an open question. Now, if they had introduced these statements at an actual trial, at a criminal trial, it's clear under existing precedents that this would have violated his Fifth Amendment rights. However, the probable cause hearing, the argument from the state is this is not. It's that the Fifth Amendment right is a trial right. It's to prevent these statements being used at trial, and it doesn't apply to various pretrial hearings of various sorts, including the probable cause hearing. So that's what the court is being asked to decide in this case: is at these pretrial hearings, including this type of probable cause hearing, does the full range of Fifth Amendment protection apply in that setting? So that's the first of the cases for next week. And again, if you want more detail on that case, you can find that in episode 26 of the podcast, where I discuss in some more detail the specific arguments on each side that are being made in that case. So the next case, so there's a second case that's being argued on Tuesday. This is Tuesday, February 20th. And this second argument is called Courier v. Virginia. And Courier v. Virginia is a case about double jeopardy. And this is a case, you may be familiar with the basic concept of double jeopardy is that a person can't be tried twice for the same crime. This case relates to a different aspect of double jeopardy that's called issue preclusion. And the idea here is instead of a case where the government tries to try someone for the exact same crime more than once, the question is, what if the government tries someone for different but related crimes in different prosecutions, but the acquittal by a jury in one of the prosecutions would necessarily mean, that they would have been also not guilty of other crimes that the government wanted to charge in a later prosecution. So let me lay down the facts here and explain what's going on here. So this case, the courier, who's the criminal defendant in this case, he was charged with participating in a theft from a home. A safe was stolen from a home, and the safe contained guns and cash. The safe was later recovered with the guns inside, but the cash was gone. Now, he was charged with breaking and entering, with grand larceny, and also with possession of a firearm by a convicted felon, because he had prior felony convictions for breaking and entering and grand larceny. Now, the issue is there's under Virginia's procedures, in order to prove a felon in possession charge, the prosecutor needs to introduce evidence of that the person is in fact a felon, so evidence of the prior felony convictions. Normally, with relation to other criminal charges, it's considered highly prejudicial to introduce evidence in court that someone has been convicted of crimes previously. It's the type of information that the belief is that jurors will kind of seize on that to see someone as a criminal character, a criminal person, and that will kind of outweigh considerations of the specific facts and proof of the crime that's at issue. So normally that's information that is not allowed to be introduced, but here it has to be introduced for the felon in possession charge. So under Virginia's procedures, typically these charges are severed. So the felon in possession charge would be tried separately from the other charges, the breaking and entering and grand larceny charges. And that's what happened. The state tried him for breaking and entering and grand larceny for the theft of this safe, and the jury acquitted him. So he was acquitted, found not guilty of the breaking and entering and grand larceny. What happened then was Virginia went ahead and tried him for the felon in possession charge. And at that second trial, he was tried and convicted and sentenced to 5 years in prison for the felon in possession charge. The thing is, the state's theory of the felon in possession charge was that that Mr. Courier had possessed the guns in the process of opening and removing the cash from the safe. He had been in possession of those guns. So the possession of the guns was part of the same set of events that involved the theft of the safe and the money from the safe. So the argument is, if a jury found him not guilty of breaking and entering and stealing the safe and the money in the safe, then it necessarily found him not guilty of being in possession of those guns in the course of opening and removing the money from the safe. So he argues that they should not be able to try him for this second offense. He shouldn't have been able to be tried for the felon in possession charge once he'd been acquitted on the breaking and entering and grand larceny. That's the way that this issue preclusion in double jeopardy cases normally works. But here, the Virginia's argument is that applies when the state has a motive of trying crimes separately in order to kind of abuse their power and just get multiple attempts to convict someone. So if they have an incident occurs and it could result in a number of felony charges, instead of charging them all in one trial, trying them all in one trial, if the state were to split those up into separate trials, try each one individually just to get more attempts to convict someone. So even if they were found innocent by some jury, another jury might find them guilty, and they get all those extra attempts to get a conviction. And that was actually there's kind of a important case from 1970 called Ash v. Swenson, which was the case that really established this issue preclusion idea. That's exactly what happened. There was a robbery of 6 people, and rather than charging someone with one trial on 6 counts of armed robbery, the government intended to have separate trials, and they charged him first with the robbery of 1 person. Then he was acquitted. They tried him again with the robbery of a 2nd person, but it was the same single incident. And here Virginia argues the only reason they're trying them separately is to protect Courier's rights. They're doing it to protect him from having prejudicial information about his prior felony convictions introduced in a trial of. So we had a little technical problem during the live stream, and the feed dropped out for a couple minutes and lost a little bit of my what I was saying. So I've just recorded this afterward to kind of try and fill in the piece that was dropped. I was talking about Currier v. Virginia, and basically Virginia's argument that because their intent was not to oppress Currier by bringing multiple prosecutions to try and get multiple bites at the apple and attempts to convict, but rather they were the reason for having multiple trials was to protect his rights, to prevent prejudicial information from being introduced in the trial of all of the criminal charges. That because they didn't have this kind of nefarious intent, that the issue preclusion double jeopardy rule shouldn't apply in this case. And Currier, on the other hand, argues that no, that this is just a general rule about respect for jury verdicts and respect for acquittals, the important role that acquittals play in our criminal justice system. And they say the government isn't prejudiced here. The government had a full and fair opportunity to litigate this particular issue, the question of whether Currier was involved in this theft. And the jury apparently found that the government had failed to prove that by returning a not guilty verdict. So that should decide the issue, and the government shouldn't be able to come back and call that jury finding into question by having a second jury decide on the same issue. So that's the basic issue in this case. And again, this is going to be argued on February 20th, and we expect a decision sometime by the end of June. I was about to go into the third case that the court's going to be hearing next week, which will be the first case that the court hears on Wednesday, and it's called Rosales Marellis v. United States. And this case is it's a case about the federal sentencing guidelines, and specifically about what happens when a mistake has been made under these guidelines. So let me give a little background of what this is about. In the federal courts, there's the federal government has something called the United States Sentencing Commission. And what the Sentencing Commission does is it creates sentencing guidelines. And what these are is these are recommended sentencing ranges for various crimes. And the way it works is based on specific characteristics of a particular crime. This could include things like whether violence was involved in the crime, the number of victims that were involved, the amount of money or amount of damage that was caused by the crime, and in drug crimes, it typically involves the amount of the quantity of drugs that were involved in the case, based on factors like this, and then also based on the criminal history of the defendant. The guidelines result in a range, and it's a range of months, a certain number of months that the person is recommended to be sentenced. And the reason for this is, for many federal crimes, the potential sentence range in the law, in the statutes, it can be extremely broad. There could be, for example, a crime that's punishable by 0 to 20 years in prison, a huge range. But the sentencing guidelines, based on the specific facts of one particular crime, will narrow that to a much smaller range. Now, these guidelines are not mandatory. A judge is required, a sentencing judge is required to calculate the range under the guidelines and required to consider that range, but is not required to follow it. And a judge is free to depart. They can go higher or lower as long as they're within the statutory range. They can go higher or lower. However, these guideline ranges are extremely influential. Judges use them generally as a starting point. And even when a judge chooses to, a lot of sentences are within these ranges. Even when a judge chooses to depart, that's usually their starting point, to start with the suggested range and then give some reason why they think in this particular case that the sentence should be higher or lower. So the facts in this case were the defendant, named Florencio Rosales Marellis. He was a Mexican national who pleaded guilty to illegally re-entering the United States after being removed previously. And he had, because he had a number of previous arrests and convictions, and these involved aggravated assault where he stabbed someone. That was what had gotten him deported from the country previously. And multiple convictions and arrests for beating his wife. So he had these assault convictions, and as a result of those various previous convictions, he had a fairly high level criminal offender level that goes into the sentencing calculations. However, the officer from the probation office who provided to the court the calculation of his sentencing range made a mistake in the calculations and actually double counted one of his previous assaults, which resulted in a higher criminal offender category. And so as a result, the guidelines range that was suggested, that was in the report provided to the court, said that he should be sentenced to 77 to 96 months, which, if you do the math, is about 6.5 to 8 years. The correct range should have been 70 to 87 months, which is more like 6 to 7-ish years. So it's a little more than half a year shorter on the low and high end of the range than the range he was sentenced under. So again, the range that he was sentenced under was 77 to 96 months, and the judge ended up sentencing him to 78 months. So it's 1 month more than the low end of the range. Now, the new range, 70 to 87 months, the sentence he actually got is still within that range. It's kind of in the middle of that new range. But he argues that because the judge sentenced him near the low end of the range that the judge was using, if the judge had the correct range, he probably would have sentenced him to the low end of that range, and he would have resulted in a sentence that was lower by 6 or 7 months, something like that. The issue is that no one caught this mistake. His attorney didn't catch this mistake. The judge didn't catch this mistake. Had the attorney caught this mistake at the sentencing hearing, it would have been corrected at the time. It would have been a simple matter, and the judge presumably would have started with that proper range and worked from there. But it was not caught, and so he raised this. His attorneys raised this only on appeal. And the issue that's coming up in this case is when you have an error like that. When an error like that is not objected to at the trial level, when can you nevertheless get that fixed on appeal? So the issue here is, in general, and this happens in many different aspects of criminal trials, if you've ever just watched parts of a trial on TV, you know that there are objections throughout the trial to various different rulings, and there are many pretrial objections to various evidentiary rulings, things like that. There's all kinds of things that attorneys object to. In general, if an attorney doesn't object to something, even if the court makes a serious mistake, something that should not have been allowed under the law, if an attorney fails to object to that, most of the time, that issue is lost. The courts, they want any mistakes or errors to be raised at the trial court level, so that a judge has an opportunity to correct things and fix things at that time, and not to be held back or not to have to go back and second guess things after the fact, after everything's all over, and try and figure out what impact something would have had it been done right in the first place. There is exceptions, though, and there is a federal rule of criminal procedure that allows, in some circumstances, allows allows courts to go back and correct certain types of errors, even if they were not brought to the court's attention. And so the real issue here is just a dispute between the defendant here and the government about how strict that the requirement is. The government argues that this should only be done in fairly rare cases. That it needs to be an extreme error. It needs to be something major before the court should go back and abandon their usual approach of not allowing when not correcting errors that aren't objected to at the time. And the defendant, Rosales Marellis, says that this type of error, since it's so clear and it goes directly to the fairness of the sentencing proceeding, because a mistake in the guidelines is just highly likely to result in a different sentence, that this is the type of thing that courts should just allow to be fixed when they're discovered after the fact. So the court is going to look at that and this broader question, presumably of how strict the court should be about correcting this type of what's called plain error. So now I'll move on to the last of the cases that's going to be heard next week, the fourth case. This one's called DACA v. United States. So this will be the second case the court hears on Wednesday, the 21st. And this is a case about wiretaps, and specifically it's about when the government conducts wiretaps under an order that was too broad. What's the remedy? Is there a right to exclude all of the wiretaps from the subsequent criminal trial? Now, what's going on here is this is a case about a specific statute. It's a specific statute that was passed in 1968 called the Omnibus Crime Control and Safe Streets Act. And part of that act, Title III of that act, involves standards for applying for and orders approving wiretaps. And the issue that came up here is that part of that law limits these wiretaps to the territorial jurisdiction of the court that is issuing the order. So the idea is, if the government comes in to a particular jurisdiction, and here this was in the District of Kansas, so that's the federal court sitting in Kansas, and the government asks a judge in the District of Kansas for a wiretap order, that judge is limited under the statute to allowing wiretaps that occur within the District of Kansas, which is the territory of the state of Kansas. In this case, the orders that were issued allowed for wiretapping to occur outside of Kansas as well. And it appears it was a misunderstanding or a misinterpretation of the statute by the judge that issued these orders. However, all of the intercepted communications, so the order allows for interception of communications outside of Kansas, but all of the communications that were actually collected and introduced at trial actually came from within Kansas, were intercepted and collected within Kansas. So they did not violate they didn't go beyond what was allowable under the statute. But the way the statute is phrased, it has a specific provision that says when communications are intercepted, when the order of authorization or approval under which it was intercepted is insufficient on its face, then the communications must be suppressed. That means not introduced at the criminal trial. So they say this just focuses, the defendants here say, this focuses on the order and whether the order was sufficient, not whether these communications could have legally been collected, but whether the order that they were collected under was insufficient on its face. And they say the fact that this order allowed for authorized collection that was not allowed by the statute means that it was plainly insufficient, and therefore all of these should have been excluded. The government argues on the other side that that's not the right reading of it. They say when it says insufficient, it means not enough information, not enough information or evidence was provided in the application for a wiretap to support it. And that's not the issue here. It's just that it was overbroad. And they say to the extent it was overbroad, the government didn't use any of the overbroad collection. They didn't use any calls that were from outside of Kansas. And it wasn't an issue of insufficient, an insufficient order. So it shouldn't apply, and the conviction should stand with the wiretaps from the Kansas wiretaps. Were perfectly fine, and there's no problem. So the court's going to have to take a look at that, and it may involve some real parsing of the statutory language and deciding what it means for something to be insufficient on its face. So that's the basic idea of that. So those are the 4 cases the court's going to be hearing next week. And again, if you want more detailed treatment that kind of goes into more depth about the specific arguments for any of those, you can look back at the other podcast episodes, either on the audio podcast or on YouTube. And again, one of them was the first one, the City of Hayes case, was episode 26, released 2 weeks ago about, and the other 3 episodes are episodes 29, 30, and 31, either on YouTube or the audio podcast. So please check those out if you are interested in more detail on those cases. And that brings us to the end of this live stream episode. Our next live stream will be a week from today. That's Thursday, February 22nd, again at 9 p.m. Eastern time. And that's our usual weekly live stream time, Thursdays at 9 p.m. Eastern. But you can also always check the Counting to 5 YouTube channel to find out when the next scheduled live stream will be. And in next week's live stream, we're going to preview the cases for the second week of February arguments. And there's a few cases in that second week that are some of the more highly anticipated cases, some cases people are really watching out for. One is a major case about compulsory union dues. Another is a case about the government's ability to get information, email information that's stored outside of the country in another jurisdiction. And there's another First Amendment case, a free speech case about the right to wear political clothing or labels or things when voting, when voting inside a polling location. Those are a couple of the cases that are coming up in the second week of February's arguments, and we'll be looking at those in next week's live stream. So whether you're watching this on YouTube or listening to the audio podcast, I would love your feedback. You can leave comments on the show notes at countingto5.com or on the Counting to 5 YouTube channel or Facebook page. You can tweet at countingto5 or send an email to me at mike@countingto5.com. Please subscribe to the YouTube channel or the audio podcast to make sure you don't miss future episodes. And thank you for listening. This has been Counting to 5.